Bienenfeld Law with Saul Bienenfeld.
Your name is in evidence. What does the law actually say and do about that? Before we begin, a brief disclaimer. This discussion is about law, not rumor. Being named, photographed, or referenced in evidence does not mean criminal conduct. There are very few cases in modern history that have generated as much confusion, fear, and as misinformation as the Epstein case has. Not because of what is known, but because of what people assume. I've heard versions of the same question over and over again. If my name is in the Epstein files, am I in trouble? Can the government come after me just for being mentioned? Should I call a lawyer? Should I stay quiet? Should I explain myself? And the problem is this. Most public discussions skips the law entirely. So today, I want to speak about one narrow, critical question. What can legally happen and what cannot when your name or image appears in Epstein-related evidence? So let's start by grounding this in reality. When people say the Epstein evidence, they usually mean one of the following things: a flight log, contact lists, emails, photographs, calendar entries, phone records, witness statements, and digital metadata. Here's the first legal truth that matters. Evidence is not an allegation. Investigators collect everything. Names appear for countless reasons: business, social, political, professional, incidental. In a criminal case of this magnitude, innocent names vastly outnumber guilty ones. Being in a database does not mean you're a suspect. It doesn't mean you're under investigation. It doesn't mean you did anything wrong. It means only one thing. Your name exists in material that the government has preserved. Nothing more. So when federal investigators review material like this, they do not ask, is the person famous? Will it look bad in the press? They ask only one question. Is there independent evidence of criminal conduct? Now, independent means that there's corroboration. It means that there's witness testimony, an actual person testifying. It means there's physical evidence. It means that there's digital proof. It means that there's a pattern of evidence. And without that, nothing can move forward. There's no warrants. There's no arrests. There's no charges. This is not discretion. This is constitutional law. So what kind of investigation could follow? Let's talk realistically, not dramatically, about what might happen. If your name appears in evidence, the government may retain the information, cross-reference it with other investigations around the country and around the world, compare it against victim statements, conduct a paper review only, run a background check on that person, and that's it. There's no knock on your door, there's no subpoenas, there's no accusations. Most names never progress beyond this stage. And importantly, you are never notified of a review that goes nowhere. There is no letter that says, you've been cleared. Silence often means exactly that. Nothing happened. This is where the public understanding collapses. Without corroboration, the government cannot arrest you. They cannot search your home. They cannot seize your phone or computer. They cannot compel you to testify. They can't put you on a list. They can't publicly accuse you of anything, and they can't leak your name legally. They can't bootstrap suspicion out of proximity. That would violate the Fourth Amendment, the Fifth Amendment, due process, and prosecutorial ethics, quite frankly. And those rules don't disappear because a case is disturbing or because it's Jeffrey Epstein. The most dangerous thing a person can do if their name appears in the Epstein files is panic. Here's the hard truth I tell clients. Panic causes more damage than evidence ever can. People hurt themselves by talking publicly to clear their names. They hurt themselves by reaching out to investigators on their own. They certainly hurt themselves by deleting evidence, deleting communications, by speculating in texts and emails about why their name appeared. Silence is not obstruction. Silence is a constitutional right. Remember, you have the right to remain silent, a constitutional right to remain silent. If your name appears anywhere in this universe, your first move should be no move at all except calling an attorney. This case is not a model for how criminal law usually works. Epstein's plea deal distorted accountability. His death ended prosecution. The evidence pool became frozen in time. Now, that creates endless speculation. It creates no final adjudication, no public declinations, and no closure, which is why rumors thrive and law disappears from the conversation. When does the government stop collecting information and start investigating a person? Because that line exists and it matters. Let's clear up one misconception right away. The government holds vast amount of information about millions of people, and most of it never becomes an investigation. There is a critical legal difference between information retention, intelligence review, and criminal investigation. So if someone's name appears in Epstein-related material, the default posture of law enforcement is not action, it's storage. Files are preserved because they might matter later, not because they do. This distinction is invisible to the public, but fundamental to the law. Here is the moment everything turns. Corroboration. It's not suspicion, it's not rumor, it's not outrage. Corroboration means independent evidence that supports a claim of criminal conduct. Now, that could include a victim statement naming a person and a location, travel records matching dates, communications confirming conduct, multiple witnesses describing the same behavior, physical or digital evidence. Without corroboration, prosecutors do not proceed, not because they're cautious, but because they're legally prohibited from doing so. This is where many people misunderstand Epstein-related material. A name alone does not corroborate anything. So what a preliminary review really does is, most people imagine investigations as dramatic, agents busting down doors and handing out subpoenas and, putting people in handcuffs. In reality, the most common step, if any step at all occurs, is something far more quieter, a preliminary review. That's what it's called. And that usually means analysts reviewing existing material, cross-referencing databases, looking for overlap with known cases, checking statute of limitations issues always. No one's going to call you, no one's going to email you, and no one's going to tell you what's happening. And in most cases, the review ends exactly where it began, silently. There is a difference between a witness, a subject, and a target of an investigation. A subject is someone whose conduct falls within the scope of an investigation, but without sufficient evidence to charge that person. Most people never even reach that level. And here's the key point. You are not automatically told you are a subject. There is no notification system for that at all, which is why reacting prematurely, especially publicly, is very dangerous. So what not to do while nothing is happening? That's the question. When nothing is happening, do not try to make something happen. So don't reach out to law enforcement. Don't offer explanations. Don't try to get ahead of the story. Don't ever assume silence means suspicion or silence means guilt. And don't confide casually in another person. Every statement creates evidence. Every explanation creates inconsistencies, and every attempt to clarify creates a risk. The law does not reward helpfulness. It rewards precision. Many people believe prosecutors are waiting to drop the hammer. In reality, prosecutors are constrained by statute of limitations, evidentiary decay, witness credibility, that's a big one, burden of proof, and certainly ethical rules. In Epstein-related matters, these constraints are extreme. Now let's talk about the moment everything feels real. The moment you get a message, a phone call, a knock, and the words that follow are almost always the same. We just want to talk. If you ever speak to a criminal defense attorney long enough, you'll hear this sentence. The interview is where most cases are made. Not the arrest, not the search, and not the trial. Interviews. Because interviews feel informal, they feel non-threatening, they feel reasonable, and they're none of those things. Agents are trained to make it seem that way, to make it seem informal, to make it seem friendly, to make it seem non-threatening, to make it seem, I just need to ask you some questions. So let's be precise. If the government wants to speak with you, it usually happens one of three ways. A phone call, an email, or a visit, often framed as informal. You might just be walking out the door of your house and there's an agent standing there. Oh, can I talk to you for a moment? And it will often include reassurances. You're not in trouble. You're not a target. We just want your side. You're not under arrest. We just want to speak to you for a while. All of those statements are probably true. And all of them can still end with charges. Because here's the legal truth. Nothing said before the interview limits what happens after it. No matter what that agent said to you, anything can happen once the interview starts. People put enormous weight on that phrase. They told me I'm not a target. Here's what it actually means legally. It means at that moment, based on what they know at that specific time, they are not prepared to indict you. That's it. It's not immunity, it's not a promise, and it certainly is not binding. And it can change with one sentence that you might say. People believe there's silent dangers of voluntary interviews. So let's talk about the word voluntary. A voluntary interview is not sworn, right? You're not under oath. It's not recorded transparently, so there's not a court stenographer there typing out what you're being said. It might be recorded secretly on a tape recorder. It is summarized by the agents. When they get back, they fill out their forms and they summarize what was said. It's filtered through reports, and it's later treated as evidence. There's no transcript that you get to approve after you have an interview. There's no rewind. There's no, that's not what I meant. What survives is their version, the government's version, not your version. So what you should do in that moment. If law enforcement reaches out to you, here is the correct response. I'm happy to cooperate through counsel. That sentence does four things. 1, it preserves your rights. 2, it stops informal questioning. 3, it buys time. And 4, it signals seriousness. It does not make you look guilty. It makes you look advised. It makes you look smart. Always tell the government before speaking to them that you want a lawyer. So here's why lawyers change everything. When counsel is involved, the landscape changes immediately. Now, what happens is questions are defined, the scope is limited, the risks are assessed, the timing is controlled, and the exposure is evaluated. Sometimes the right decision is to speak, sometimes it's not. But that decision is never made in real time under pressure and alone. That decision is made with your attorney. Clearing your name could be a trap. One of the most dangerous impulses is this. If I just explain this, it will go away. That instinct has destroyed more innocent people than silence ever has. The law does not work on explanations, it works on proof. And once words exist, they cannot be unspoken. You cannot unring a bell. Let's be clear. Silence is a constitutional right. Silence is a legal strategy, and silence is a neutral act. Silence is not obstruction. Silence is not evasion. Silence is not admission, and certainly silence is not guilt. The system is built to withstand silence. People are not. Now, in cases like the Epstein's case, time distorts everything. Memories fade, records fragment, people reinterpret past events through present narratives, and that makes interviews especially dangerous. The interview is not a conversation. It is evidence creation. And the most powerful word you have at that moment is not an explanation. It's a pause.